As you might have guessed from my introduction, I am going to switch the focus of human rights away from copyright from the first talk to patents. So I'm actually going to focus my talk in three parts. I'm first going to talk about what I consider to be a big problem. And second, I'm going to ask, well, would recognizing human rights more help? Short answer, not so much, but it's very complicated. Third thing is, well, what do we do now? And I'm not saying human rights is irrelevant, but I don't think just sticking the label human rights on is going to be enough, as we'll talk about. Okay, so what is the problem that I'm going to focus on? I'm building on the great discussion we had this morning in terms of suggesting that one thing that needs to be more broadly recognized than beyond the people in this room is that to promote human rights, we need to recognize that investor-state arbitration is actually having a major impact on IP rights and the ability to use these so-called TRIPS flexibilities. So to take a step back, in case students aren't familiar with what TRIPS flexibilities are, when TRIPS and the WTO was created, that was a huge watershed agreement because for the first time, suddenly some states had to provide IP rights. But it was built in that there would be flexibility to decide how to define key rights. And as subsequently litigated in, for example, the Eli Lilly case, states traditionally assumed they had flexibility to define terms that were not defined. So for example, for patents, all countries have to give patents on inventions that are new and useful, for example. But useful is intentionally not defined to let every country implement as they saw fit. So that sounded fine. For some countries who said, well, we'll get other stuff out of the WTO. But after that, there were so-called TRIPS Plus agreements, where countries kind of wanted more. We got this, that was good, but we can do even better. So there are agreements requiring more, and there was even an agreement proposed to have standard requirements, which never got enough agreement. And what we're seeing now, I think, in ISDS is a different kind of thing. So whereas we've previously talked about having TRIPS Plus agreement going above the TRIPS standard, technically investor-state disputes don't require states to do more, but it's more the threat of being sued and subject to millions of dollars that is imposing a TRIPS Plus-like obligation. Now, just to highlight a couple points from the cases discussed this morning, unique IP laws were thought previously to be okay under TRIPS flexibilities. And that was an issue both for Eli Lilly and Uruguay. And although they both won after spending a lot of money, it could be trouble for states ahead who want to use TRIPS flexibilities. And also on the specific kinds of investment claims, there's also particular issues. So for example, in Australia, Philip Morris made the creative argument that fair and equitable treatment, which is a very broad standard, was violated because arguably they thought Australia didn't comply with the TRIPS rules. And they wanted a non-WTO panel to rule on that. So fortunately, the panel figured out that there wasn't really a dispute between the parties that were supposed to be there because all Philip Morris did is reincorporate, so that went away. But we have now provided a template, as this morning's panelists discussed, for other countries to make this exact same argument where they are properly incorporated. So I still think it's a major threat, and it seems inconsistent with the spirit of the World Trade Organization's dispute settlement understanding, which was intended to have one forum to resolve all disputes under the WTO and TRIPS. Now, moving to the Eli Lilly v. Canada case, obviously, there was an issue with their different interpretation of useful. And then although they won, again, in some ways, they got lucky. And they got lucky because it was a matter of not having enough proof for the tribunal. So importantly, the tribunal never said, well, countries can have different interpretations. It was unquestioned that if you had a different law, that might be a problem, which is, again, inconsistent with TRIPS flexibilities. So what I think is interesting and important to recognize is that many academics had previously thought, this is a crazy case, of course they're going to win. And they did win, but not on grounds people were necessarily expecting, and that tribunal never said this was a frivolous case. There are sometimes frivolous cases. They didn't think this was one. So depending if another company had different evidence, they could win because a country decides to exercise its TRIPS flexibilities. Also, some of the arguments made in Uruguay that the tribunal found persuasive wouldn't have helped, like the police power to regulate. So it was not a regulatory exception, it was a judicial evolution of common law. And although, again, there's nice language about how the tribunal shouldn't be an appellate body, it's not binding, and maybe it'll be different in another case. So I find all of that very problematic. In addition, although after the case, I read a lot of stuff saying states are completely free to regulate after the Eli Lilly win, that's not true. There's just not enough press about the problems. So in 2017, there was a case brought by Novartis against Colombia. Why? Because Colombia used, or they were thinking about using, a TRIPS exception. So what happened was Novartis was selling their cancer drug Gleevec for a cost of $15,000 a year, which is double the gross national income per capita. So it's not a good fit with the needs of the country. So there were discussions of a price cut. They didn't actually cut the price. They didn't actually issue a compulsory license yet. But just the discussions were enough to prompt Novartis to file an investor-state dispute. That's a huge deal. But unfortunately, I don't even know any more than that because under that agreement, transparency is not required. So I don't know the basis of the claims, don't know what happened. My guess is after that, they stopped discussing price cuts, which is the goal. And again, if you're supposed to do compulsory licenses, but you can't actually do it because of the threat of investor-state disputes, that's a big problem. So to me, the huge problem is that beyond this room, there's not enough acknowledgement that ISDS impacts human rights. My one favorite example is in 2016, the UN High-Level Commission issued a report on how to promote innovation and access. Big report, it's been discussed ever since. And the goal was to fix policy incoherence between international human rights, trade law, and public health. Where's investor-state disputes in this? It's not a section. The Eli Lilly case is cited in a footnote of an example of how, well, companies shouldn't challenge rights, but it's buried away. And the rest of the report, which goes on and on, is like, use your TRIPS flexibilities, without recognizing you can't really do it if you're going to be sued for millions of dollars and Bloomberg doesn't bail you out. It's just not going to happen. I don't think. I mean, there's not unlimited money to go around to bail out everyone. So what should we do now? Would embracing human rights more help in the ISDS space? Not necessarily. Why? The first thing is a lot of the tribunals take a very literal approach, and they're like, we have to promote the goals of this agreement. The agreement is only about promoting investor rights. So even on the general principle of we should have balanced rights in IP, that's not recognized. Human rights, generally not in there. Even if you go beyond the explicit text, you still have to think about which human rights. So I would say you have right to information, like Professor Flynn was saying, right to promote public health and access to medicine. But what's not always discussed is that corporations are big believers that they have human rights too. And they have gone to court to argue, as one of my panelists will talk about, or has talked about in the past, that they also have human rights. And they should not be infringed by overbroad exceptions. So focusing even on the human right to health is not a grand slam. But even if you put aside the corporate interest to human rights, drilling down to the human right to health is still kind of tricky. So technically, we're supposed to promote highest attainable standards. Now, what does that mean? People have said there should be a right to affordable medicine. But in general, even when there's agreement, it's generally only about access to essential medicine, which I'm pretty sure no one would argue was the drugs in the Canada case. ADHD, even if you say this is like a real thing, people aren't going to die without their ADHD medicine. Well, maybe the parents feel that way, but technically they are not dying. Same thing with the antipsychotic drug. So that's a tricky thing. Another tricky thing is I think that companies are fairly careful in how they do these disputes. I think they intentionally chose Canada and drugs that did not have a good claim to right to access health. Because if they did, then they'd get jumped all over. Or they file against a case or like Colombia where there isn't transparency, so it's not well publicized. I think there's also other issues that haven't really come to the front yet, such as maybe human rights includes a right to information about health, which ties into some states wanting more transparency of clinical trials. But that's even more disputed. But that could also be something that compromises the right to attain best health results because companies don't always have an interest in sharing data that is not so helpful. So what do we do now? My big picture suggestion is that we need more awareness beyond the people who already know that this is an issue. So I think there are some examples in the recent past that show that greater awareness can lead to positive results. So for example, in the EU, with the TTIP agreement, there was a lot of public concern about investor-states disputes. That was enough to make the EU bow to criticism and have public consultations, as a result of which there were serious proposals about having an actual investment court and appellate body. Whether or not it happens, we don't know, but that's been the biggest movement so far. Similarly, TPP, once the US exited, not only did they dump some IP provisions that the US wanted, they did cut back on investor-state disputes. Not all the issues that I personally want, but it shows that if there's awareness raised, something can happen. So what should we do? I totally agree with what was mentioned this morning, that it would be helpful to limit the scope of investor-state disputes to exclude, not include IP from the scope of investments. It's a little hard to do so retroactively with the 3,000 plus existing agreements. Theoretically, the tribunalists could do that themselves. I'm skeptical that they will, but I guess you can always make the argument and hope for the best if you have enough public awareness. I personally think that if there are high-profile cases, like the Uruguay case, like the Canada case, the tribunalists maybe are going to put more thought into what they emphasize or don't emphasize. So for example, even I know there was a lot of criticism of the dissent to the Uruguay decision, and I'm not supporting the dissent either, but he did not contest that the state had within its police powers the right to regulate, just not on the single presentation requirement. So sometimes you can get a consensus on some issues. Some other things that I would recommend that might help if we could get agreement would be maybe limiting IP investor-state disputes to just states bringing them, making it more like the WTO system. I could see some countries, i.e. the US, not going along with that, but that's, again, something we could hope for. We could also try to change the definitions of expropriation and free and fair and equitable treatment to limit them. So, for example, maybe expropriation and fair and equitable treatment, that should be cabined to things that are consistent with TRIPS. Of course, the question is, who decides if it's consistent with TRIPS? So up until Australia's tribunal dismissed its case, we had what I thought was going to be a huge collision between the WTO and an investment panel deciding what is a TRIPS violation. Fortunately, we won't have a collision anymore, but it could still happen. So I would actually suggest maybe a new hybrid system. So we either amend the dispute settlement understanding or create a new mechanism for investor-state disputes where if there is a TRIPS issue, maybe it would be better if the investor-state panel would stay their dispute and have the WTO decide it and then defer to it. I think I'm asking for a lot. Like this is like, my big Christmas dream and maybe it'll never happen, but that would at least resolve the inconsistency issue. So that's kind of like an overview of like all the different things I would love to happen, but I think first things first is just even making awareness an issue on the agenda of both the World Health Organization and the UN to help mobilize more troops to get interested in the matter. Thank you.